Hello, my name is Austin Gage, and I am doing a presentation on the Westboro Baptist Church and how it deals with freedom of speech. All U.S. Supreme Court cases relating to free speech must start by considering the protections granted by the Constitution and Bill of Rights, and how previous Supreme Court decisions have applied those protections to the real-world situations. The First Amendment of the U.S. Constitution reads as follows: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of people to peaceably to assemble and to petition the government for redress of grievances. Since passage of the First Amendment in 1791, the rights it protects have consistently been given broad protections by the U.S. Supreme Court. Often, the right of free speech has been at the center of national moral debate that questions how much freedom a culture can stand. Because of the power of speech to do harm, many U.S. Supreme Court decisions and state laws have created restrictions on how free speech may be expressed. One area of restrictions imposed on free speech that is relevant to the Westboro case relates to the time, place, and manner in which speech can be exercised. In a 1994 case called Madison v. Women Health Center, Inc., the Supreme Court ruled that protesters picketing at an abortion clinic were required to stay at least 36 feet away from the front door of the clinic and could not shout at or otherwise harass patients going in and out of the clinic. In a 1999 case called American Civil Liberties Association v. Reno, the Supreme Court ruled that protesters could not picket on public streets outside the residence of a doctor that performed abortions. In the Reno opinion, the court said the First Amendment allows the government to prohibit speech that is offensive and intrusive because a captive audience cannot avoid it. In a 2000 case called Hill v. Colorado, the Supreme Court upheld a Colorado law making it illegal to approach anyone within 100 feet of a healthcare facility without their consent for the purpose of giving them literature, displaying a sign, or voicing a protest. Several elements of the Hill case decision are particularly relevant to the Westboro Baptist Church situation. First, the 2000 Supreme Court ruled that the Colorado law represented an acceptable balance between the constitutional rights of the law-abiding speakers and the interests of unwilling listeners. Secondly, the court said restrictions that reasonably regulate only the time, place, and manner of speech, and apply equally to all demonstrators, regardless of their viewpoint, and are enforceable. The Westboro case centers around the free speech protection given by the U.S. Supreme Court in March of 2011 to picketing protesters at the funeral of children, murder victims, and soldiers by members of the Westboro Baptist Church, a small church with 100 members from Topeka, Kansas. The Westboro free speech case began in 2006 when church members picketed the private funeral of Lance Corporal Matt Snyder in his hometown of Westminster, Maryland, carrying signs that read, "God hates fags and Matt is in hell." Matt's father, Albert Snyder, filed a case against the church in state court for intentional infliction of emotional distress and received a jury award of $11 million. The Westboro Church got that decision reversed by the Federal Appeals Court on the basis of free speech, and Albert Snyder appealed that decision to the Supreme Court. Now I'm going to show you a video.
Controversial signs and often heated exchanges. The tactics of the Westboro Baptist Church have become familiar, most often on display at the funerals of U.S. soldiers. After they showed up at services for Lance Corporal Matthew Snyder, a young Marine killed in Iraq, his father, Albert Snyder, decided to sue, all the way to the Supreme Court. Today, in an 8-1 opinion, the justices found that Westboro's speech, which links America's war debt with what this church views as the moral decline of our country, was public in nature and protected by the First Amendment. Quote, "Such speech cannot be restricted simply because it is upsetting or arouses contempt." In today's opinion, the court acknowledged that Westboro's protest at the Snyder funeral was painful and that it added to Mr. Snyder's, quote, "already incalculable grief." But Justice Samuel Alito was the only one who thought Westboro crossed the legal line. As the lone dissenter, he wrote, quote, "In order to have a society in which public issues can be openly and vigorously
So that video shows the seriousness of the situation. As the video of the Fox News story shown in the presentation explains, in March of 2011, in an 8-to-1 opinion in the Supreme Court ruled that subject of the funeral protest by Westboro church members was of national interest and therefore is entitled to free speech protection. In a lone dissenting opinion, Justice Alito said free speech protection should not be given to protests at private funerals, which he claimed were entitled to overriding protections due to a personal right of privacy. Legal scholars have pointed out that the Supreme Court has previously upheld laws prohibiting demonstrations at private funerals, so the Westboro decision might have been different in Maryland had such a law. Largely because of public outcry over the Westboro case, and with support from the Obama administration and leaders of both political parties, all states have now either passed laws prohibiting protest demonstrations and at private funerals or are in the process of doing so. As often happens with precedents set by important U.S. Supreme Court rulings on First Amendment free speech cases, the Westboro case may not be over. In October of 2011, a St. Louis federal court struck down a Missouri law restricting protests at funerals, while months earlier, a Cincinnati federal court ruled that a similar Ohio law was not an unreasonable restriction on free speech. Because conflicting federal court decisions on similar laws can only be resolved by the U.S. Supreme Court, it is possible the court may elect to include the case of conflicting federal court funeral protest decisions on its 2012 schedule. If the court uses the Missouri and Ohio cases as the basis to take a second look at the issue, Albert Snyder may get the justice he was seeking when he first asked the U.S. Supreme Court to protect his right to have a private funeral for his son over 5 years ago. Thanks so much.